in a rally because he or she wants to get elected. That's for sure.
The tide has very clearly turned. Nowadays, mediation is said to occupy a very important position within this broad concept. It is firmly established in many legal systems and is growing acceptance in others. It is approached as a flexible and easily tailored way of parties to work out solutions to their disputes in many different fields, favoring the continuance of their relationships at the same time. But at that same time, too, many important differences exist, not only in relation to the legal framework developed globally, but also its scope and solutions provided. And also its solutions provided. When I say solutions provided, I would touch onto the enforceability aspects of mediation. When you have a settlement agreement, how then do you come to enforce that settlement? So I opened my arbitration practice and mediation practice in 2014, and I moved out from an in-house corporate counsel from in the banking and financial industry to running a fully pledged arbitration and mediation practice. But I felt like a pioneer because I was doing something new and innovative. And I dreamed of one day that when mediation would be as well known and used by the public, such as the courthouse and the lawyers' consultation. I still dream of that day. Mediation would be in every corner of our society and would model an interdisciplinary and consumer-oriented approach. That hasn't quite happened in Tanzania, but mediation is also, because I guess, it hasn't happened, but with the initiatives that my firm, along with other people in the society are making, we would realize mediation to be the mainstream method of dispute resolution. I also wanted to touch on whether this practice should either be regulated or not. In Tanzania, of course, we have no regulations, no laws in respect of mediation. To this date, we also don't have an independent institution such as BIMS providing for mediation services. Now, although I would further touch on the fact that mediation itself is used in different industries, for example, the labor dispute resolution mechanism of choice is mediation, and it has also proven to be very successful in our commercial, in our commission for mediation and arbitration that deals with labor disputes. It's also provided for in our court annexed program, which is faring away positively, but is not being used according to the laid out process or mediation process because of the judges lacking the skill to drive or facilitate a mediation in accordance to the principles that we're all aware of when it comes to mediation. Though I still believe strongly in the value of mediation, but I think there's a need for further innovation in Tanzania and elsewhere. Specifically, I think we need to develop a practice of peacemaking that arguments our mediation work. Although peacemaking differs from mediation in its impact on the people we serve and on a conflict resolution, as conflict resolution professionals. Ladies and gentlemen, if I could refer to a speech by Indira Gandhi, he said, "You cannot shake hands with a clenched fist." Now, peacemaking means taking concrete positive steps to help the parties unclench their fists, improve their relationship, and prevent the conflict. Mediation is fundamentally a process with a beginning and an end. However, peacemaking is not a process. As I said before, it's a set of values. It's a set of personal attributes, goals, and behaviors that guide you to be able to move the parties from one end to another. Many mediators, I would say, are peacemakers. Many are not. Many peacemakers are mediators. Others have different roles, many of which are not neutral. Peacemaking means creating a sense of peace and mindfulness within our own lives and in our work by harnessing those core values that I spoke of. It means making a commitment and using our skills to impact the colleagues and institutions with which we work with, as well as those in our wider communities, professional communities, and beyond. It means devoting our mediation efforts to improvement and repair of parties' individual lives, repair of their relationships, and preventing future disputes. Therefore, we need to provide educational awareness, resources, supportive professionals who are agreement ready, in an agreement readiness design. These peacemakers' roles go beyond sitting down with the parties and trying to help facilitate an agreement. These roles require strategic planning and a commitment to carve out time and space to make the fist unclenching process work. Ladies and gentlemen, studies also show that mediation was a key component, or is a key component, in successfully resolving and transforming conflict, underlining its great potential as a powerful conflict transformation tool. A number of scholars have looked at the use of mediation and its potential to conflict transformation. It is based on the premise that mediation as a process in which a third party helps the conflicting parties in resolving the conflict without imposing a solution is considered an effective tool, not only for resolving conflict, but also transforming social relationships and building peace. The transformative story proposes that the power of the mediation is to be found in its ability to transform the quality of the conflict interaction, thus strengthening the character and capacity of the disputants and of the wider society in which they live in. It is opined that a mediator, as a third party, is tasked with the helping to transform this hostile relationship and find new and attractive options for both parties that seem attainable. Consequently, a reality-grounded transformation where the parties or the positive aspect of the dispute are emphasized and become more viable to the parties. I haven't had the formal training in transformative mediation, I must confess, but I think I've been practicing it in a transformative way. It is those magical moments of transformation that keep me in the business. The goal of the transformative mediation is to change unjust social structures, prevent conflict, and promote peace. I say this because if you get a dispute, a business dispute, and you're able to transform the parties into maintaining their relationship despite of having that dispute, it should feel very good at the end of the day, because they will end up with a settlement agreement, yet also further have an agreement to continue trade with each other and maybe also enter into other ventures. And so this is the transformative aspect of mediation, that parties actually end up realizing the value that is maintained within their relationship. Ladies and gentlemen, while it's difficult to measure, the impact of moving beyond mediation to peacemaking is significant, both to the participants and to you, both professionally and personally. The parties benefit from a true resolution to a dispute rather than narrow settlement of dollars. Of course, a settlement of any sort is clear a case from a court docket and it's clear of a court docket case and let the parties move on with their lives. Sometimes that is all the parties want or are capable of achieving. Yet, when you offer a peacemaking approach, that includes a broader exploration of future or possible future relationship repair, possible systematic reform, and even elements of apology. The participants may go further with the possibility of greater satisfaction with the result of the mediation and the process that made such result a reality. And a byproduct of peacemaking is not just increased mediation skills and perspectives from the mediators, but increased personal satisfaction in more important life's work. Perhaps the greatest difference peacemakers can make is by adding conflict prevention into their mediation work. When people enter a formal mediation process, there has already been a failure because they have a dispute, informal claim or actual lawsuit has ripened to the point that they need the mediator to intervene. And so conflict prevention is something that I would highly propose for us to consider prior to the parties getting into the mediators' chambers. Ladies and gentlemen, to conclude, in his article, Mr. Woody Worston believes that our quest and work for deeper peace and a long-term impact on the participants who are at the mediation can take place in the mediation room when mediators also become peacemakers. The mediator must take a proactive approach to get business actors engaged. Mediators can identify and build a common interest, develop an open door information policy to invite that support, and use moral pressure. I will say that the proven success of the already established work on mediation pushes us to outstand our ambitions, to firstly expand the study of mediation within our communities, our judicial cultures, and around the world. This symposium actually is already a step in this direction, and to create a federative sort of structure of mediation systems that clusters the countries of all the continents. I wish you all to continue this innovative work of anticipation and openness for the benefit of justice. I would repeat the words of the keynote speech, Dr. Ramin. There is no way to peace. Peace is the way. Thank you.
I have some question too. In your country, what type of mediation you practice? For example, in our country, we practice office-based mediation also, community-based mediation. Office-based mediation mainly conducted by the lawyer. And community-based mediation, what we do, it is a very traditional institute and very long institute. Mediation, there are mediators. Sometimes we found they are not following the law, state law properly. So we capacitate them on the laws, and we also bring some community people who have the leadership capacity, and they conduct mediation. And we do follow up their mechanism also. So what type of mediation? That is one of the issue I want to know. I think there are many people, they want to know. And you know, we face challenge to make the mediation women friendly, because we found there are many cases we settle through mediation. Most are family related cases. But in the rural setting, we observe among the mediator, very hard to find any woman as a mediator. But the issue is wife beating or maintenance case. So that is also a problem, trying to build a woman as a mediator. So it is a long way to go. And capacity enhancement for the mediator, you mentioned very well, that is inspiring. And yeah. And other thing, how do you follow up after mediated a case? Yeah. And so many questions, sorry, because the area is mine. And other thing, if any party is not satisfied, then how you handle these cases? And we also observe there are some criminal offense. According to law, we cannot settle through mediation, but we observe there are many criminal cases like acid violence case, rape cases are being settled by the mediator. Then we opposed, and it is not legally we can do that. So how do you handle? Do you face any similar problem?
Mediation do we have in Tanzania? As I said in my opening remarks, was that mediation is still very much lagging behind as a practice in Tanzania, especially on a private basis. However, we do have court-annexed mediation, which is under our Civil Procedure Code. This code is really just a replicated version of the Indian Civil Procedure Code. And so just recently, of course, we've tried to update it with regards to the commercial division, meaning the mediation of court-annexed mediation for commercial cases, with updated rules on the mediation that is court-annexed. However, that is still not effective as of yet, because we're waiting for the Parliament to pass these new rules and laws. And so we're hoping maybe by next year we will be having an updated court-annexed program. Currently, it's poor because of the fact that, one, the mediators are the judges. The judges are poorly skilled with mediation. As you've also noted, the capacity issue is a very big issue in our country. And with mediation, there are certain skills that we have to have in order for us to be able to ensure that the facilitation of the resolution is adhered to by the parties. However, that is lacking. Now, also the second issue is the role that the lawyers play in the mediation, especially the court-annexed mediation. We find that most of the time, actually all the time, the lawyer will go to the mediation session that is fixed by the court without having prepared even a settlement proposal, or without even going with the person who is equipped to make the decision, so who has the power to make the decision. And so we end up maybe conducting mediation 3 times because, oh, first day they'll turn up, we need to adjourn because we don't have the capacity to agree. But all in all, it's very effective because once you have that mediated court settlement agreement, then it's as good as you have a court order or a court ruling of some sort. Now, in other fields, we would have a specific division for our labor disputes. So we do have a structure under our labor laws that has been created, and it's called the Commission for Mediation and Arbitration. And that is a commission that mediates labor-related disputes. So for example, an employee is aggrieved by their termination of employment, and they say that I have been wrongfully terminated by my employer. They have one place to go, which is the CMA. They have to initiate their claim at the Commission for Mediation and Arbitration. If they fail at mediation, then the mediator will mark it as failed and it will go to arbitration. However, I go back to capacity. Our Commission for Mediation and Arbitration mediators are still needing a lot of capacity building initiatives to be done. So that's where we're lagging behind. And of course, the caseload there, because it's a structure that is provided for by the government, the caseload is very high. And so that's where we find some mediators sort of getting out of the way of the process and just marking failed the minute the parties sit down, without even trying to facilitate some sort of an agreement. We also have mediation happening in other fields, such as the insurance sector. There's a particular body for that. I'm vice chairman of the Tanzania Institute of Arbitrators, but we don't provide any mediation. We've never received any mediation. We're an independent body. The National Construction Council as well, because the construction disputes, they have already got already internationally sort of dispute resolution structure that they use within their construction contracts, that it goes straight to the National Construction Council. However, mediation is not very much practiced there as well. So there are very many opportunities for growth in mediation in Tanzania, and I think across many developing countries that we need to look at. Community-based dispute, you touched on that. We currently have not got community-based mediation happening. However, I see that there are some initiatives. Of course, the World Bank has certain initiatives in the country, especially on land-related disputes in the rural areas, you know, when it comes to the rural areas, educating the people there that they can use mediation for settling any sort of dispute that arises with respect to land. And that will touch on also family disputes as well, yes. But not very much of a practice, I would say. And the issue there is, of course, the knowledge of the fact that the mechanism is available for them, and capacity, who or the resources to conduct those mediation or to teach and sort of transfer the knowledge to these people who need that sort of skill. You also asked on whether the family law provides for any mediation. Yes, we do have a reconciliation board. However, that reconciliation board is somehow outdated because our law of marriage is dated back to 1967 and needs to be totally revamped because the law is extremely outdated. And so the reconciliation board is there, but mediation of family disputes is somehow not practiced at all. That I can confirm. One, also because of the cultural issue. You know, we're used to keeping our marriage issue very within ourselves, and so we don't want to disclose to a third party what is going on within our families. And so that's also one thing of the fact that family mediation is not very much practiced. And I don't think we have any accredited family mediators in the country at all. With regards to workplace mediation, meaning the inside the office, the company mediation, that is also not practiced. Even though our labor laws do allow for private mediation within the company itself, not many companies have a policy that is an internal policy providing for mediation within the company itself. Follow up after mediation. Now, this is really just comes back to you as the mediator and what kind of practice you're running, yeah? So I once say that with mediation, whatever mediators do or do not do reflects their understanding of the nature of the conflict and their responsibility or response to it. The why upon which what we do and how we do it is really up to us. So what happens is that, yes, you have your negotiated settlement agreement, yeah, your NSA, but the parties may not abide to it. And really, you'd figure it out from the first meeting as to whether the parties are really honest in their approach to their mediation. And so most of the times when I see it's a difficult people dispute or a difficult dispute that would give rise to some sort of a problem, what I would do is that the negotiated settlement agreement would be recorded in court under a summary procedure of some sort. But of course, because we don't have a law on mediation, and so you have to be creative. And of course, when I was chatting to Asha from India, she gave me a very good solution to this problem, where you have a negotiated settlement agreement, the other party doesn't want to comply to it. What do you do as a mediator? And she suggested something that she's doing in India, which is med-ab, mediation, then arbitration, meaning that, you know, whatever you mediated in the mediation can be recorded as an award by an arbitrator, and then now you have an award which you file in court. I don't know if you do it here, but you file it in court and it is considered as good as a court judgment, yeah? So I would do that. You know, I've learned from Asha, and that's why I say these symposiums are so good, because you get to meet different people from different parts or ends of the world, and you get to get solutions to apply to your own practice. And so that's one thing. The second thing is obligations management. You know, we have a contract, which is the negotiated settlement agreement. How do you manage the obligations of each party in that contract? And so if you have an obligations management matrix created, you could assign someone, not yourself, because you know maybe you're a very busy mediator. You could assign somebody who could be able to follow up on those obligations from each end of the stick, and I think that could work as well. Criminal offenses. I think that's my last question on criminal offenses. We currently don't have a mediation or sort of a program that works hand in hand with our criminal justice system. And I think it's a very good question, which touches on a very important aspect of our society, because if juveniles, for example, you know, in the juvenile courts, if they're given the opportunity to mediate their case and be able then to serve whatever it is that is mediated, then that sort of diminishes the impact you make on this juvenile, as opposed to just sending him off to a juvenile jail. So I think mediation is something that could be used. There are certain studies that are there with respect to ADR and criminal justice sort of initiatives, and so you could look into that as well and get a deeper dive. I'm not a criminal lawyer, but I would say that it could work. It will work if it's applied correctly. Yeah. Thank you.
Symposium is a speech by Professor